My respected colleagues, senior advocates, members of the bar, young advocates and friends in the legal profession, good morning. Today I am not here merely to criticize one individual. I am here to raise a question which concerns every lawyer in this country. When the bar demands accountability, why the Bar Council of India Chairman must resign to save the independence of the bar? My friends, who owns the Bar Council of India? Does it belong to its chairman? Does it belong to a political party or an ideology? Or does it belong to the legal profession and function according to the Advocates Act, democratic principles and the rule of law? My answer is unequivocal. The Bar Council of India belongs to the bar. It does not belong to its chairman. And that is why I believe that Manan Kumar Mishra should resign as a chairman of the Bar Council of India. The question is no longer about one individual. It is about the independence, dignity and credibility of the bar and the Bar Council of India. My friends, the demand is no longer only from outside. For a long time, many of us have raised concerns about the functioning of the Bar Council of India. We have said that the BCI must not convert it into anybody's personal fiefdom. Today, something much more significant has happened. The demand for resignation has come from inside the Bar Council of India itself. The co-chairman, senior advocate Y.R. Sadashiva Reddy has demanded the resignation of Mr. Mishra. BCI member Manoj Kumar Narendran from Kerala has demanded his resignation. Another BCI member, Advocate Srinath Tripathi, has supported the demand. And now the campaign for judicial accountability and reforms has also called for his immediate resignation. The reputed daily The Hindu has reported that the growing pressure, including a gathering of more than 200 lawyers outside the Bar Council of India's office demanding transparency and reform. A petition has also been reportedly filed in the Supreme Court of India challenging the legality of his prolonged continuance as a Bar Council chairman. My colleagues, when demand for change comes from within the institution itself, we cannot treat it as a personal quarrel. It is an institutional alarm. Let us first address the most serious financial allegation. The BCI co-chairman has alleged that approximately 150 crore rupees of BCI funds was sought to be transferred to a trust known as Peril First. I emphasize this is an allegation and must be independently investigated. But can the legal profession simply ignore an allegation involving 150 crore rupees of the funds of its statutory regulator? Certainly not, my friends. Let the documents be produced. Let the trust deed be produced. Let the resolutions be produced. Let the accounts be audited. Let the bank transactions be examined. Let the source of utilization of money be disclosed. If everything is perfectly legal, an independent audit will establish it. Truth does not fear an audit. Then there are also allegations that the law colleges seeking recognition or renewal from the BCI were being asked to make substantial contributions to the trust. This is extremely very serious allegation. The Bar Council of India has regulatory authority over legal education, but regulatory authority is not a license to raise funds. If colleges were asked to contribute money as a condition connected with recognition or renewal, the matter requires immediate independent examination. And if the allegation is false, let the BCI publish the records and establish that fact. Transparency is the answer, not the denial. My friends, CJR has now also raised questions regarding the constitution and functioning of Peril First Trust and alleged that it took over funds of an earlier BCI trust. It has stated that these matters are being examined by the CBI. Again, we must not pronounce guilt before the investigation, but we must demand the investigation. The bar is entitled to know who created the trust, who are its trustees, who controls it, and what money went into it, from where, who authorized the transfer, how was the money utilized, what is its relationship with the Bar Council of India, and what is the legal basis for the entire arrangement. These are the reasonable questions. The money belongs to the institution, and the institution must account for it. My friends, now let us come to an issue which should we should deeply concern every lawyer in the country. On August 13th, an extraordinary direction was issued from the chairman office concerning the graduating students of Nalsar. State bar councils were directed not to enroll the entire graduating batch until an inquiry was conducted. What was their alleged offense? They had participated in a campaign questioning the invitation of the Chief Justice of India as chief guest at their convocation. The direction was withdrawn within hours, of course. The inquiry was subsequently dropped and an apology was also later issued. But I ask, can peaceful dissent destroy a student's professional future? Can a law student disagree with the constitutional authority and thereby lose the right to enter into legal profession? Can a statutory regulator create a disqualification which Parliament has not prescribed? My colleagues, if we accept that principle, tomorrow it may be a law student, the day after tomorrow it may be an advocate, and eventually it may be any of us. Dissent is not a disloyalty. Questioning authority is not an anti-nationalism, and peaceful protest is not professional misconduct merely because the person in authority dislikes it. My friends, the BCI member Manoj Kumar Narendran has raised another fundamental concern. He has questioned the practice of issuing statements in the name of BCI without adequate deliberation or authorization by the General Council. This is very crucial. BCI is not a private office. It is a statutory body. The General Council is not ornamental. It is the collective institutional authority of the Bar Council. The chairman is an office bearer. He is not the institution by himself. One individual cannot continuously speak in the name of the entire legal profession without the authority of the institution. If that happens, the distinction between the BCI and its chairman disappears. And when that distinction disappears, institutional democracy disappears with it. Then what about his 14 years in office? My colleagues, let us ask another uncomfortable question. Can one individual remain at the head of the statutory democratic institution for 14 years? The Hindu has quoted the BCI co-chairman making a powerful observation that an elected office with one occupant for 14 years has ceased in any real sense to be an elected office. CJAR has also questioned the use of the provision permitting continuation until successor is elected. BCI member Narendran has questioned the amendment extending the chairman's tenure. These are legal questions for the competent authority to decide. But the democratic principle is indisputable. No office should become a lifetime entitlement. Institutions require rotation. Power requires accountability. Leadership requires renewal. Otherwise, an elected office gradually becomes a personal office. There is another issue we cannot avoid. Mr. Manan Kumar Mishra is a BJP Rajya Sabha member. Let me make it absolutely clear. There is nothing wrong with a lawyer entering into politics. That is a democratic right. But the chairman of a national statutory regulator of the legal profession must maintain institutional independence and neutrality. The BCI cannot become a political perch. CJAR has used precisely that expression. The bar must not be seen as an extension of any political party or ideology. It must not be used to please political masters. It must remain independent of governments, political parties, and all centers of power. The bar must be free to question everyone, including the government of the day. That is what professional independence means. My friends, there are also allegations regarding appointments to the BCI and the associated institutions, including allegations concerning relatives or persons connected with the chairman. We should not pronounce anyone guilty without examination, but we should demand transparency. Publish the advertisements, publish the qualifications, publish the selection committees, publish the merit list, disclose conflict of interest. If everything is clean, there is nothing to hide. My dear colleagues, let me make one thing very clear. This is not a personal campaign against Manan Kumar Mishra. It is a campaign for the independence of the legal profession, the bar, It is a campaign for transparency of BCI, Bar Council of India. It is a campaign for collective decision making. It is a campaign against arbitrary exercise of statutory power by a single individual. It is a campaign to ensure that no future chairman, whoever he or she may be, can use the institutional machinery of the BCI as a personal power. That is why CJAR has demanded not only the resignation of the chairman but also an independent inquiry into the trust, full public disclosure of the Bar Council of India finances, institutional safeguards against unilateral punishment of students and advocates, and a binding limitation on the tenure of the BCI chairman. These are not unreasonable demands. They are demands for institutional reform. What should happen now, my friends? I am not asking for a conviction without trial. I am not asking for guilt to be presumed. I am asking for something much simpler. Let there be an independent inquiry. Let there be an independent audit. Let the trust records be examined. Let the BCI accounts be examined. Let the law college contribution allegations be examined. Let the appointments be examined. Let the null-sir decision be examined. Let the legality of the prolonged tenure be decided by the competent court. But to ensure that such an inquiry has credibility, the chairman should step aside. That is the honorable course. So my message, Mr. Mishra, if you believe that these allegations are false, you have nothing to fear from an independent inquiry. If you believe that the financial transactions are completely lawful, let the audit establish it. If you believe that the peril first trust is completely legitimate, let the documents speak for it. If you believe that the null-sir action was justified, let the law determine it. But please do not allow the institution to suffer because of a personal battle and prestige. Step aside. Resignation is not necessarily an admission of guilt, Mr. Mishra. Sometimes resignation is the highest form of institutional responsibility. So now I appeal to the bar. My friends, we cannot demand independence from the judges while surrendering our own independence. We cannot defend free speech for our clients while remaining silent when law students are threatened for expressing an opinion. We cannot demand transparency from governments while tolerating opacity in our own institutions. We cannot tell governments that public office is a public trust and then forget that principle when it comes to the leadership of our bar. The same constitutional standards must apply to us, my dear colleagues. The Bar Council of India is too important to be personalized. It is too important to be politicized. It is too important to be centralized in one individual. And it is too important to be surrounded by allegations concerning its finances and functioning without a transparent and independent examination. Not to any family. And BCI belongs to legal profession, not to its chairman, not to a political party, not to any individual, not to any family, not to any private trust. It belongs to the bar and must function according to the law, democratic procedure, collective responsibility, and constitutional values. Therefore, in the interest of the dignity of the legal profession, the credibility of the bar and Bar Council of India, and the independence of the bar, I reiterate my demand that Mannan Kumar Mishra should resign as chairman of the Bar Council of India forthwith. Let an independent inquiry establish the truth, and let an independent audit establish the facts. Let the institution be restored. Let the bar regain its voice. And let us send one clear message, my friends. The Bar Council of India is not anybody's fiefdom. The bar is independent. The bar will remain independent, and the dignity of the legal profession and bar cannot be compromised. Thank you, my friends.